Welcome to the inaugural webinar of the Corporate and In-House Counsel Committee of the Chartered Institute of Arbitrators, Nigeria branch. My name is Ireti Oluwabanjo, and the topic of our webinar today is getting it right from the start, dispute resolution clauses that work. Before we begin, would you like to tell us where you're joining from? I'm joining from Lagos, Nigeria, and it's a rainy day today. Where are you joining from? Can you put it in the chat room? Let's know where you're joining this webinar from. Who goes first? Where are you joining from? Okay, so while we're waiting to see that, I'll quickly call the chair of the Corporate and In-House Counsel Committee, Dr. Nike Esson, FCIR, for the opening remarks.
Good afternoon, everybody. My name is Adenike Esson, and I'm the chair of the Corporate and In-House Counsel Committee of the Institute of Arbitrators, Nigeria branch. I want to warmly welcome everybody for participating in this webinar. This is our first webinar, and I'm very glad that you registered and you are here now to participate. The committee was set up in March, and we are fully constituted, and want to thank the Executive Committee of the Chartered Institute of Arbitrators for setting up the committee, which mandate is, amongst others, is to foster inclusive engagement of corporate and in-house counsel committee, and to also ensure capacity building, and to ensure that our voices are heard in the thoughts leadership, policy making, and in other, initiatives relating to the arbitration community within Nigeria and outside Nigeria. Again, my assignment here is very short, and it's very, should I say, it's simple to welcome you and to leave you in the hands of our seasoned, experienced speakers, moderator, who will talk to you about getting it right. I think it's the first, is our first webinar, and the topic is very apt, getting it right, a dispute resolution clause that works. So I would say, please participate. It's going to be an interactive section because you have an opportunity to, to ask questions, and you can put your questions in the chat box. Okay, so back to Ireti Banjo, who is the session coordinator. And thank you once again.
Thank you very much, Ma. Thank you for opening this event. Oh, back to the chat room. We're seeing people joining from Lagos. Colbert is joining from Accra, Ghana. That's great. We have Nelson from Birmingham. Jiwo Kim from London. Oh, thank you so much. We have Cynthia from Abuja. Thank you very much. We have RL from Accra. Thank you. Fubara Samuel from UK. We have Kemi from Benin. Thank you so much for joining us. We're thrilled to have you here. Yes, and our topic is getting it right from the start, dispute resolution clauses that work. We are in-house counsel, and most times we're seen as cost centers. But we're here today to show you how you can show your management you're actually adding value by reducing the costs that would have been expended on dispute resolution by using effective dispute resolution clauses. We have a very powerful panel here this afternoon. I'll be reading out a very brief profile before we start. We have Mr. Julius Echikonye. You're welcome, sir. He is a senior legal counsel for Shell Nigeria Exploration and Production Company Limited. He's a lead lawyer for Shell's gas business in Nigeria from 2016 till date. He regularly facilitates, and he's been a speaker at international conferences, and we're sure to get marvelous insights from him today. You're very welcome, sir. Also, we have Mrs. Hawa Kaka Usman. She's the General Counsel and Registrar for Nigerian Chamber of Commerce and Commerce Dispute Resolution Center. She has served as sole arbitrator, co-arbitrator, and co-counsel in arbitration proceedings. She has mediated several family and commercial disputes. She's an Islamic arbitrator. She's a specialist in that area. Thank you very much, Ma. We're happy to have you here. We also have Mr. Ibrahim Kito. He is the General Counsel, Director Legal Services for Energy and Petroleum Regulatory Authority, Kenya. He's had at least 15 years post-admission and near a decade experience in the energy sector and in the corporate world. Thank you very much, sir. All the way from Kenya, we Nigerians were saying, welcome, sir. And yes, our moderator for today's webinar is our own Folake Sadiq. She is a barrister and solicitor of Supreme Court of Nigeria. She's a member of the Chartered Institute of Arbitrators, and she's the Assistant Secretary. She's a recipient of the African Arbitration Academy Scholar and member of the drafting committee of the Model Bilateral Treaty for African States. Her key interest is in the resolution of technology disputes, data privacy, and cyber security. Folake is the group counsel for she's the group general counsel for Westfield Energy Resources Limited. You're welcome, Folake. So Folake will be taking us through the panel sessions. Folake, you can take over now.
Thank you very much. Good afternoon, everybody. Thank you so much for joining. Apologies, the plan was to be in my office to take this webinar, but how things happen, I'm stuck in my car somewhere, and instead of missing or disappointing, I'm just going to have to take it from my car here. Just had to deal with some
Thank
work
you so much,
emergency.
Folake.
Thank you. Thank you to the in-house counsel committee. I think this is a very great initiative, and particularly giving us in-house counsel, the fact that it gives us in-house counsel the opportunity to talk about arbitration. We are one of the first users of arbitration, and having this platform to talk about different things that affect us. For that, I would like to thank the Chartered Institute of Arbitrators. And that brings me to the topic at hand, getting it right from start, drafting arbitration, drafting dispute clauses that work. That is very instructive. The topic is the best way to start, in my opinion, because we're starting from the beginning. And with that, I would like to welcome my esteemed speakers. Ms. Ireti Banjo has given us a short profile. If she was to read the entire profile, we would spend about 30 minutes just reading the profile of this extremely powerful panel that we have here. But we're very mindful of the time. If I could just see my speakers, if you could just indicate that you're here. Good afternoon.
Yeah, good afternoon. I'm here, Julius.
Good afternoon, sir. And Madam Usman, good afternoon. Mr. Kito, good afternoon. So we'll just delve straight into...
Good afternoon, Folake. Thank you.
Good afternoon. Good to see you again. We'll just delve straight into it. So the question at hand here is getting it right, arbitration clauses, dispute resolution clauses. And I would like to pose this question to the three speakers, which is, what has been your experience so far?
Are we still on? I think Folake's screen froze. Huh?
I think her screen froze. I don't know who she was asking the question. Perhaps the person she was asking can just take over and take over from.
I think yeah, you are right.
So if I may, and can you confirm you can hear me?
Yes.
Okay.
Yes.
And that's a good foundational question, talking about experience with, drafting, getting it right, drafting dispute clauses. A couple of preliminary points that would help lay the foundation for what one would be speaking generally on today. One is a recognition that when we talk about contracting, people get into contracting, it's about, voluntarily assuming risks and potential liabilities. I mean, if people are in a transaction that poses no risks and has no potential for liability, they may not bother with a contract. So they can just decide to go on with whatever they are doing. But because we recognize the risks, we recognize potential liabilities, we put things down in writing. So drafting a contract, for me, is all about allocating those risks and potential liabilities. And the dispute clause is one of those mechanisms through which we allocate the risks that we see in a transaction, and the use to which you put a dispute clause depends on what you are seeing in your transaction. And that's why one of the things I recommend to any young lawyer who wants to get into drafting agreements generally is you must understand the industry to which you belong. You must understand the customs of the trade. You need to understand the particular transaction you are getting into. It's not enough to say, we want to do this and you begin to draft. No, you also need to understand the business environment, the legal environment in which you are playing. Now, all these will come together to enable you draft a proper and effective dispute resolution clause. Now, getting it right is about ensuring that these foundational aspects are there. Then when you get into, because one of the reasons, the main reason we draft contracts, at least in my organization, is to avoid dispute in the first place. The secondary reason is when it does happen, then what do we do to put us in good stead when it does happen? So our focus is not so much on the dispute clause as in making sure that whatever we draft is practicable, is implementable, and then when we come to the dispute, we know that it may be inevitable at times, and when that does happen, we are the right forum, we are the right place, and we have the right people looking at our dispute and resolving it. Because dispute resolution has a lot to do with the integrity and credibility of those who are saddled with the duty to resolve the dispute between the parties. If those people are not well informed, if they lack the expertise, if they don't have what it takes generally, including the integrity, then you're likely to have in your hands a dispute that could go against you, not because the facts and the merits are not on your side, but because you have chosen either the wrong forum or the wrong set of people to look at them. Let me pause there and allow my colleagues to chip in before I come back. Thank you.
Okay, I'll want to add to what Julius has spoken to. And for me, I think the first thing is that an ideal dispute resolution clause should first of all not invite or incentivize a dispute. And for this, what I mean is that it must come with it what we call clarity in terms of the purpose, must be brief enough. As well, it should be practical, like Julius has actually said. And then of importance is what we speak to as what we call fitness for purpose. That means then if you are talking about the dispute, then the clause should be able to clearly state what will be the seat of arbitration, what will be the place of arbitration, what will be the applicable law. And then, of course, the other thing is that should identify the proper arbitral body or tribunal or institution. And then, very important, the clause should be robust enough, but not be overly prescriptive to prevent, addressing other emerging issues as it relates to arbitration, which may occur after it has long been drawn and, included or mainstreamed into the contract against which it's meant to serve. So I think those will be my few comments about what to look out for in establishing or carving out a fit for purpose arbitration or dispute resolution clause.
Good afternoon, everyone. Good afternoon, Dr. Nike.
Good afternoon, Ma.
Yes, good afternoon, everyone. Thank you very
Good
much. I
afternoon.
will start by expressing my deep appreciation for your invitation for me to participate in this very important topic and getting it right from the beginning, drafting an arbitration clause or a dispute resolution clause that is essentially clear at the beginning is very important. It's key. And for parties drafting a dispute resolution clause, following a model clause, which is the usual thing that we do, and like Mr. Julius and Mr. Ibrahim have said, it is important to know how to tailor it to suit the purpose at the time that, to suit the purpose and the contract for which it is being drafted for. And in that situation, the different transactions that you have, whether it is a construction dispute transaction or it is an oil and gas transaction, whatever the kind of transaction, it is important that it is tailored towards that transaction. Parties should, in rare cases, subtract from a model clause. If you find a model clause, then it is important that every aspect of the elements of an of a dispute resolution clause that will, at the end of the day, be valid, enforceable, and effective are present in that clause. So it's not just about drafting the clause. It is important that at the beginning, counsel or lawyers who are drafting the dispute resolution clause have it at the back of their mind that the agreement at the end of the day, the dispute resolution clause or agreement, as it were, must be one that is seen both in form and in spirit to be valid, to be capable of being enforced, and to be effective at the end. Because if these two other elements are not there, then at the end of the day, it becomes an ineffective dispute resolution clause. So I think I'll stop here. These three things is what I really want to say at this stage, that the dispute resolution clause must be valid, must be seen to be effective, and also must be enforceable.
Thank you very much,
Thank you.
Mrs. Howard. Thank you. Oh, Falake, are you back? Okay.
Yes. Sincere apologies. Okay. Thank you very much. I will just go to, the next question, which is for Mr. Kito and Mr. Julius. Madam Hawa, please, because you work for an arbitral institution, I would like you to sit this one out because you would have your own model clause. So the question is, what do you consider as an ideal model arbitration clause? What are the core elements of such a clause that such a clause would have? Or what would you recommend that an ideal model dispute resolution clause should have? Mr. Kito, do you want to start?
Okay, Foleka, yes, I think I'll not mind to start. For me, I would say that An arbitration clause is ideal if it's fit for purpose, like I said, and fit for purpose means that it must be able to serve, the particular subject matter out of which the dispute resolution clause, whether it's arbitration, is being proposed or to be integrated into the contract. So firstly, it must be able to serve the specific contract against out of which it's being drawn. The other thing is that firstly, it must be able not to be overly elongated to prolong the process for dispute resolutions. It must be brief enough, but of course, it can be layered enough to take care of all the aspects of ADR. The other thing I'm looking at is it must be able to speak to the 5 integral aspects of an arbitration clause. And of course, when you're talking about an arbitration clause, you should be able to have the clause speak to what will be applicable law in terms of determining the arbitration, what will be the seat for the arbitration, things to do with which is the applicable arbitral body, or the tribunal. Is it an institution, or will it be an individual, or is it a tribunal of more than 3 people? And then, of course, very important is that I will expect the clause also to facilitate disputes by not inviting disputes in itself. That means it must be very clear to avoid another dispute to arise out of it in terms of interpretation. So that's what I'm looking at. Or that's what I'll be looking at in terms of dispute resolution clause. But allow me to mention one thing. When I spoke about the fitness for purpose to serve the particular contract for which is being drawn, I'm looking at a case whereby, for example, if you're looking at a power purchase agreement, an ideal dispute resolution clause should be able to take care of expert determination as the default method. And then when you're looking at maybe contracts dealing with infrastructure, you'll expect that an ideal dispute resolution should be able to speak to maybe having a dispute adjudication review board or dispute review board. And of course, you should also expect that beyond that, it should have escalations, maybe in the form of arbitration in the event that the DAB is not able to sort out the dispute. But then at the very start, it should also be able to take care of what one can call amicable dispute resolution practices, like, resolution of disputes at the point of, at the field, looking at the technical people resolving, maybe the team at the ground, which is managing the project, maybe escalation to the respective chief executive officers, and then ultimately a possibility of negotiations and mediation. So that's what I'm looking. But the caution should be, it should be brief enough not to prolong the process.
Okay.
Or invite another dispute within it. Thank you.
That's very instructive. I'll come back to some of the things that you said. But in the interim, Mr. Julius, you want to take it from there?
So I would try not to repeat what Kito has said, but let me just mention, for complex transactions, and I deal with a lot of very complex transactions, 2 key things that are not very obvious on disputes. One is where you have CPs in a contract, and CPs, I mean conditions precedent to the effectiveness of the contract. You need to ensure that the disputes clause becomes effective from day one, from execution of the contract. Just make sure that it is effective from day one of the contract, because dispute can arise once you have put pen to paper. There can be dispute. And if the dispute resolution clause is not yet effective because you have conditions precedent to the effectiveness of the contract, then you have a problem in your hands if you have a dispute at that point. The second, again, not so obvious, is that the dispute clause must survive the termination of the contract itself, because the dispute could actually arise after the contract has been terminated. Now, all that Kito has mentioned are all very important parts of a good disputes clause. But these 2 parts are very essential if you are not to shoot yourself on the foot. And I have found from experience that a lot of people make the mistakes of not paying attention to these 2 points, and that's why I wanted to highlight them here. Now, understanding the counterparty also helps me in drafting a bespoke disputes clause. And what do I mean by that? If I look at the counterparty, I look at your experience in the industry, I look at your penchant for disputes, and I begin to tell myself, where should we, assuming there is a dispute, and there's a saying that when the shark and the lion fight, the venue is very critical. If you fight in water, you know who will win. If you fight on land, who will win is also different. So we need to understand to the point of where do we place emphasis when we are drafting this dispute clause? And that leads us to when we make choices, and I'll allow you to ask the questions of where we want our disputes resolved, who we want it to be resolved by. Let me stop there because of time pressure, and we can take the other questions.
Yes, sir. Thank you very much. I like what you said, that the dispute resolution clause should be effective from day one and should survive the agreement. And that's very useful, because that's what will ensure that the parties always know where to go and how to resolve the dispute. So still with you, I'm sure you're an energy lawyer. It's not unusual for you to see dispute resolution or even draft dispute resolution clauses that running into pages, 2-3 pages sometimes. How do you strike that balance between how detailed a dispute resolution clause should be, being well thought out and whatnot, and not creating a problem, not adding to the problem when the dispute actually arises? Because in as much as we want the dispute resolution clause to be detailed, we also don't want a situation when it's time to actually effect the clause, actually appoint arbitrators or whatnot. The clause itself is a problem. How do you prevent that in your practice, sir?
All right, thank you very much for that question, and very important one in practice. Let me say that I have drafted dispute clause that was 1 paragraph. I have also drafted dispute clauses that are 2 pages. Now, it depends on the nature of the transaction you are dealing with. I can compress in a paragraph everything that tells you by referencing the law that should apply, Arbitration and Mediation Act of Nigeria, and say you adopt the procedures there, and you've written your clause, and everything will just be by reference, and it enters into 1 paragraph, maximum 2. But it depends. There are matters you would have, transactions you'll be involved in, where you are providing, and I'm talking about you are taking seriously things around those technical issues that need to be resolved by expert determination. For instance, matters that need to go to disputes board, matter before they even get to arbitration, if at all you have to get to arbitration. Matters that need to go to the senior executives of the respective parties to see if we can resolve these before getting into adversarial proceedings. Now, when you have to draft all these and you have to make provisions, copious provisions, then you have sections for your dispute clauses where you're providing for expert determination, providing for disputes board, providing for, and bringing in which matters will be governed by which part of these dispute clauses. So, but one key thing is don't overdraft. What we learn in law school about the ABC of drafting remains germane at every point. And that is the accuracy, that is the brevity, and that is the clarity. You must learn to bring all these 3 into your drafting. It must be accurate, it must be brief, and it must be clear to anyone reading it.
Thank you very much, sir. I will then go, Madam Usman, I will come to you, but I will go to Mr. Kito. You are also an energy lawyer. I don't know if the fact that there are a lot of energy lawyers on this call is was something that the committee planned beforehand. But you're also an energy lawyer, which means that you've seen a lot of cross-border disputes. You've seen a lot of disputes that involve complexities, and you deal with such contracts, complex contracts. In drafting such complex contracts, is there anything you do differently? I mean, so it's to speaking to our audience, how do you treat a contract that you know that, oh, this is probably a small scale dispute? What is the kind of dispute resolution clause you would use as opposed to something that is a little more complicated?
Okay. Yeah, thank you.
And what are the problems that may occur in such drafting process?
Yes. Thank you for Lucky. In fact, I'll say that in determining what kind of a dispute resolution clause you'll have in any particular contract, of course, the guiding factor firstly, what is the matter at hand? What contract are you developing the dispute resolution clause to serve? So the first thing, the aspect of the scale and size of the contract is actually very critical, because you'll be wary to ensure then that as you develop a dispute resolution clause, you will not have a dispute resolution clause which is looking at an arbitral tribunal or body of more than 3 people when the dispute is so small, or the contract subject to the arbitration clause is so small. So that's the first thing, the size and scale of the project. Then the other thing is that the dispute resolution clause must also be able to appreciate or take care of the expertise, the specific expertise required in that particular contract the clause is supposed to serve. But then in terms of drafting, one of the key things one is expected to do is that, and I think I like what Julia said, you need to ensure that you are not overly prescriptive. For example, it will be very risky to have a dispute resolution clause which from the outset identifies who is going to be the arbitrator by name. That will be very risky. So those are some of the things you need to take care of. Then, of course, in terms of complexities, it's also good to be appreciative of the sector the particular contract the clause is supposed to serve, relate to. For example, in highly complex infrastructure projects, you find that the ideal dispute resolution clause should be able to take care of identify aspects of DABs, that's dispute avoidance, and also dispute review boards as the default method. And then, of course, in addition to that, to also create a culture of avoiding the disputes, it's also good to create other tiers at the primary stages of a possible dispute to take care of that in terms of amicable dispute resolution through negotiations, good faith in negotiations, discussions among the team members at the field before you escalate even perhaps to the respective executive of the two contracting parties. But then the other thing you also need to take care of and identify, for example, in the sector for energy, whereby you are talking about agreements like power purchase agreements or energy purchase agreements, you find that most of those matters are actually technical. So to that extent, then a good dispute resolution clause should be able to take care of things to do with expert determinations as opposed to arbitration. So those are some of the things one needs to have in mind in drafting dispute resolution clause. And of course, like I was saying, there are also other contracts you do not even need to have a dispute resolution clause, perhaps because the amounts subject of discussions of the contract are so small that they can be sorted without necessarily mainstreaming a dispute resolution clause. So for me, the size, scale, and pace of the project, the specific area the dispute may relate to is also very important, because it speaks to the kind of expertise you'll be looking at in terms of identifying the arbitral tribunal which should be able to take care of that dispute. So those are some of the things I think I should be able to pick out immediately. Thank you.
Thank you, Mr. Kito. Size, scale, and pace. Interesting. Madam Usman, you work for a dispute resolution institution, and as such, you have seen all sorts of dispute resolution clauses. I remember that I once saw a dispute resolution clause that brought two dispute resolution institutions together because it mentioned those two institutions. It talked about conciliation, it talked about mediation, talked about arbitration. It was so complex that some of the biggest, it brought big names from the arbitration sector. Nobody could make a head or tail out of it. I think that was the best example of a midnight clause that I've ever seen. It was where it was supposed to be arbitration, somebody just copied and pasted and just put mediation. It was just topsy-turvy. So I'm sure you've seen a lot of pathological clauses. How do you handle such interpreting such clauses and ensuring that the idea that the parties had when they signed the agreement comes to fruition?
All right. Thank you very much for that question. And I think, well, let me start by saying that basically pathological arbitration clauses are clauses that are so poorly drafted, right, that could lead to disputes in itself. And Mr. Kito have talked about how people, lawyers draft arbitration clauses that at the end of the day becomes even the dispute itself. So, I mean, several times we've seen the different kind of arbitration clauses that at the end of the day becomes impossible to act upon. Just like the example you have given. Once you have brought in two different arbitration bodies to sit over the same dispute, from the beginning, it becomes difficult to even apply that arbitration or that dispute resolution clause. So the whole idea, and I'm not sure at that point it's even possible for even the arbitration institution to even salvage some of those kind of wrongly drafted or poorly drafted dispute resolution clauses. And there are so many cases like that, even in court, that at the end of the day defeat the whole purpose of the dispute resolution clause, which makes it difficult for even the court to even allow the parties to go into arbitration, which means that at the end of the day, those kind of dispute resolution clauses end up in court. Because even as an arbitral institution, when you go ahead to act upon those kind of clauses that are so poorly drafted, it robs the whole jurisdiction of the arbitral tribunal. And if the arbitration tribunal does not have the jurisdiction because the purported clause that is supposed to give it jurisdiction has not been properly made out at the beginning, then it's just so difficult to implement. So most of the time, even here, when we see those kind of arbitration clauses, we do not apply them because you won't want to go into a fruitless journey. Except, of course, you're able to bring back the parties together to sit together and have, for instance, maybe redraft the arbitration together, which might also be a difficult thing to do. Because once the dispute starts, it's difficult to get the two parties at the beginning to sit on the same table. Although that's not impossible. But if you're able to get the two parties come together, then you could, at the end of the day, maybe result into drafting a submission agreement and then finding the two parties to discard that first arbitration, just like you have in the Arbitration and Mediation Act. So unless, of course, parties together agree to also to make the arbitration clause except parties themselves now sit to except they decide otherwise, then it will be difficult for you to make that arbitration clause effective in the first place. So we've had circumstances, even in my office, where we see the kind of dispute resolution clauses that we, at the end of the day, have to invite the parties or the party who has submitted it and advise appropriately whether to bring the other party to the table so that we could sit down and redraft that arbitration by agreement of both parties, or at the end of the day, parties will have to go to court to determine whether or not that application, that arbitration or dispute resolution clause can be effective. And just to add, from what Mr. Ibrahim and Mr. Julius have said regarding keeping an arbitration clause simple. Of course, following the model clauses, there is no one size fit for all arbitration model clause. Arbitration model clauses are meant to be adaptable. For you as a counsel or as a lawyer drafting an agreement, to also make sure that the dispute resolution clause in that agreement is looked into properly. Model clauses are good templates, but the party drafting the clause for a particular dispute, and it's important that for every dispute or for every contract, for every type of transaction that parties are engaged into, they look at it very well. And like he said, there are circumstances where you look at the kind of dispute that you have at hand, and you will realize that maybe it is only mediation clause that you need to add into that dispute. You really don't need arbitration. But because some people just copy and paste the arbitration clauses, you see a simple contract where where it is a three-panel arbitrator is asked to be yes. And then at the end of the day, when you look at the case, even the amount in dispute is not such that three-panel arbitration could sit down to decide. So in all such circumstances, you might have to either bring the parties again to look at this, to look at the clause after dispute have arisen to see what they can do about it. Probably have to come back and do a submission agreement where they change the terms completely of the initial agreement, or at the end of the day, the matter will have to go to court. So most of the time when we see those kind of dispute resolution clauses, it's either to be on the safe side, you refuse to implement, and then you allow parties to take a decision.
Thank you very much. That's why it's very important to get it right, because the likelihood of getting parties to execute a submission agreement after the dispute has arisen is extremely slim.
Difficult.
It would take it would take very, very cooperative parties to do that.
Unless there is good faith at the beginning, it will be difficult for you to get the parties together.
Thank you very much. Sir, Mr. Julius, I'd like to come to you now, sir. It's not unusual to see, and Mr. Kito also mentioned it, multi-tiered dispute resolution clauses, where you would have mediation first, or negotiation first. It might even have project level negotiation, then executive level negotiation, then mediation, then arbitration. Such clauses are quite usual, especially in complex contracts. But in your experience, are there certain, because those kind of arbitration clauses have become quite common, are there certain situations where you would say that is a no-no? There is no need to have a multi-level dispute resolution clause because for whatever reason? Are there situations where you wouldn't advise such multi-level dispute resolution clauses?
Yeah, I mean, everything depends, like I have said at the outset, the environment, who you are dealing with, etc. I mean, if you think, for instance, that discussion is not going to get anyone anywhere, it's just going to be a waste of everyone's time. Why put it in? But those are rare cases. Most times, business people want to be able to get on with their business. Disputes happen on them, and not that it is what they want to do. So most business people would also prefer not to get into the complexities of disputes and managing disputes. In other words, when we were negotiating the transaction, we sat down across the table and we negotiated the contract. When there is a dispute, why can't we sit down and negotiate it? That's the thinking of business people. Let me say that business people see particularly adversarial proceedings as, something so difficult to comprehend that they would rather not get into it. So the answer to your question is there may be rare cases, and they will be rare when you say, I don't want all these initial preliminaries that will lead nowhere. They are not binding anyway. The outcome are usually not binding. They are just steps to the next level. And you want these things decided urgently. Yes, you can have such situations, but my experience largely is that those come in very handy, where you want discussion at different levels to try and see if you can resolve this. And one of the things we do in drafting dispute clauses is to put in reasonable time limit for those so that we are not saddled with procedures that will take a long time and in the end make nonsense of the effort to resolve the dispute. So if we're going to have all those multi-tiered, and which we do have, and which is encouraged, you want to put some time in to each step of the process and say, look, at the project level, if you can't resolve it within 7 days, at the executive management level, if you can't resolve it within 14 days, at this level. And what that tries to also tell us is to gauge the reasonableness of the parties. It helps you to gauge that as you move on in the process. Now, what is really not acceptable is that you spend time doing all this and it leads to nothing and you still end up with adversarial proceedings. Where you contemplate ahead that is where you will end up, then you want to say, guys, let's not get into all that. Again, is how much is involved. Now, one of the things, and if I speak to what Madam Hawa spoke about, and that is when you have, one of the things I have seen in practice is that parties are prepared to come together and agree on some cost-efficient process when they know that litigation is on a cost indemnity basis. Now, if you practice in a jurisdiction where cost is not so huge, it's not on indemnity basis, people take things for granted and they won't agree. But my experience is if you practice where if you have wasted everybody's time, you end up paying the cost, which could even be more at times than what is at stake. People tend to be reasonable and want to agree on something that will ensure that at the end of the day, the business we got into does not become a frustrated effort. We don't end up losing all the money to resolving disputes.
Thank you very much, sir, for that. And I know that multi-tiered dispute resolution clauses are more or less here to stay. There are even situations where some organizations have just adopted, oh, this is the only method of dispute resolution that we would use. For example, I know a particular IOC that has said, oh, we must explore mediation first before we do anything else, right, sir? But playing the devil's advocate here, sir, I'm going back to you, Mr. Julius. Are there situations where you wouldn't even use a dispute resolution clause at all, and you just prefer that we go into litigation, that the parties just litigate? You're muted, sir.
Yeah, speaking from the experience of my organization, we avoid litigation. We do all we can to avoid litigation, because the challenge in litigation is you are not in control of two of the parties. You are only in control of yourself. The counterparty and the court, they're not in control of them. Now, in arbitration, it's easier because the parties are making the choices as to who. So you are partly in control or responsible for the choice of your arbitrator, and the arbitrator you chose is also partly responsible for the choice of who becomes the presiding arbitrator. And I'm talking about in a case of 3 arbitrators. And that element of weighing your risks, and we get to, depending on the nature of the matter, when we make a choice as to who will be the arbitrators. And I'll give you an example. We look at, is it a shipping experience? Is it a commercial experience? And those are 2 different things. So when we check who was appointed by the other party, we look at how they are positioning the issues. Are they positioning it as a commercial matter? Are they positioning it as a shipping matter? And when it comes to assessment of damages, who do we think will assess it better? That determines who we choose as our own arbitrator, determines who we accept as the presiding arbitrator. So when you look at all these things, I'm saying having an idea of who is determining your case is a key part of our dispute resolution mechanism. And you can't do that in litigation. Your case is assigned to a judge, and you live with that judge. And that's a nightmare for most business people. So going into litigation without exploring alternative dispute resolution, arbitration, is almost a no-no, unless it is foisted on us.
Thank you very much, sir. And that's for our litigation lawyers that may be joining us. Please always put your parties in situations where they would explore dispute resolution for other forms of alternative dispute resolution first. Sir, you mentioned something about how some of the things you think about when you're appointing an arbitrator. And with that, I will go to Mr. Kito and Madam Usman. What are the key things you look at? You have a dispute resolution clause, and it's now time to appoint the arbitrator. What are the key things that you look at when you're appointing an arbitrator to sit over a dispute? I would start with Mr. Kito, please. Mr. Kito? You're muted if you're with us. Okay. Madam Usman, can we hear from you, please?
Okay. Okay, for me, I will say what is the first thing you look at actually is subject matter of the dispute. The subject matter of the dispute determines the expertise required. So even in this even in our center, what we do first when we get application to appoint an arbitrator, the first thing we look at is what is the subject matter of the dispute, and then which arbitrator is experienced in that subject matter. And that's why these days, I think there has been a lot of clamor to have subject matter expertise in arbitration. Most people have been trained as arbitrators generally. So, but to have subject matter, because these disputes arise in different sectors. Mr. Julius have mentioned it. One of the things they look at is actually what the arbitrator is bringing to the table. If they know that a certain arbitrator is likely to give more damages or determine whether it's a shipping, what is exactly the dispute at stake, and then what's the likelihood that the arbitrator will tilt towards what the other party or the counterparty is seeing as the essence of the dispute. So another thing also is the availability of the arbitrator, because arbitrations are supposed to be a faster way to get to the access to justice. So an arbitrator must also be available. There are some circumstances where you invite arbitrators to take cases, but they're the ones stalling the arbitration process. So apart from expertise, the subject matter of the dispute, you must also ensure that the arbitrator is available to hear the reference and to determine the reference as fast as possible, because time is of the essence in arbitration or any dispute resolution. And like we said, even when you have a multi-tiered arbitration clause or dispute resolution clause, there has to be timing as to how many days within which, if parties go into negotiation, they are unable to resolve the dispute, they will move quickly to mediation. And if parties are unable to mediate within a certain time, a certain period of time, then they should be able to move quickly to the next stage. So there has to be timeline for every aspect of the dispute mechanism that have been chosen, so that it's not just left open. If you leave it open, then even with it, it's just go back to what we have in litigation and where we are trying to come back to the alternative dispute resolution. The whole essence of it is to have somebody who is ready to properly and expeditiously conduct the arbitral proceedings without unnecessary delay as have been provided. So those are the factors that expertise.
I think Madam Hawa is now muted.
Okay.
Okay. Thank you.
Can you hear me? Did you get the last part of what I said? Okay.
Yes, I believe so. I believe so. Thank you very much. While we wait for Mr. Kito, Mr. Julius, I'll quickly go to you. Which would you say you have a preference? I mean, in what situations do you use an appointing authority? In which situations do you use ad hoc arbitration? Appointing authority obviously means that you go to, when there is a dispute, the parties go to an arbitration institution like the Chartered Institute of Arbitrators to appoint the arbitrator. While with ad hoc, it is the parties appointing the arbitrator themselves. Do you have a preference? And I'm asking that question if, in light of the situation we have, where, if we're being realistic, we have this, I don't want to call it a pandemic, but this situation whereby we have a local,
so it's important to manage your client's expectations and let them know it will not be possible.
Can we mute, please?
Over promise and undeliver and do a surely job.
Can we mute, please?
Because ultimately you will be acting in.
I think it's sure.
Okay, thank you. Yes, I was saying that this situation we have whereby the parties are local, but you will find that the arbitral institution is foreign. Why? Why? Is this a preference? And that is very regular with our bigger companies. Why does this keep happening? Is there a particular preference for international arbitral institutions?
Quality client service. I think that between billable hours and service.
Some interruption.
Yes.
Okay, so if you can hear me, let me start with the opener in your question. I mean, any preference? It depends. I mean, where you have single arbitrator to deal with a matter, then there's a preference for institutional appointment. And that is also borne out mainly because at times it's difficult getting both parties to agree on a particular arbitrator. So you want to go to an institution to help you with making that appointment straight away without any lot. And you want to go to a reputable institution for that when there is a whole lot at stake. You don't want an institution that will appoint someone based on some, non-meritorious, if I use those words, reasons. But apart from that, where there is three, the preference is usually to make an appointment yourself for either party to appoint. Like I had mentioned earlier, it helps you because strategizing over the dispute management starts from the appointment of the arbitrators itself, how you want to position it and what you are telling the arbitrator. So you want to have some input into that. And my experience working closely with business people, and I'm talking about as against lawyers who do the drafting, is they want control, they want involvement in anything that has to do with the transaction that they are undertaking. So what I would say is the second part of your question, why do you go to jurisdictions, different from where the parties are? A number of things contribute to that in my experience. Now, you want to look at when you want to, again, first is that dispute resolution is already out of your hand. If it's not, the initial discussion, negotiation is not within your control. So the last thing you want is ambiguity. The last thing you want is a system or process that is not very credible. The last thing you want is lack of standardization in a process. What you really need is a system that you can analyze and say, this is likely to be the outcome. And what that tells you is, do I offer a negotiation pathway? Do I go to approach the other party to try and see if we can settle this matter? Or do I allow it to go the whole hog? But that transparency, how transparent, how credible the system is, how credible are the people who will resolve this dispute is very key in making that decision as to where you go to, the venue, and the institution you'll be approaching to resolve your dispute.
Thank you very much, sir, for that. We still have a few more questions, but I'm very conscious of the fact that this webinar is supposed to last just for an hour, and we know that we're all business people. We have things to get back to. So in kind of closing the session, because we still intend to take questions from the audience, I would want the speakers to just answer this final question and use this question to round up, which is, what advice do you have for in-house counsel in particular and lawyers in general when it comes to arbitration clauses? To round up. I don't know if we still have Mr. Kito.
Yes, Folake, I'm very much around.
Okay.
Allow me to comment something as regards the choice of an arbitrator, because I think I was to contribute to that.
Yes, we couldn't hear you.
Without repeating what my colleague spoke to, I think there are some other things one may need to take care of, and the aspects to do with the due diligence, which may be able to unearth some things like a possible conflict of interest for an arbitrator, because of course you don't want to appoint an arbitrator, then the first thing you have to deal with, the arbitrator has to deal with, is dealing with preliminary issues on conflict of interest, or even the award being impugned on the basis that the arbitrator was conflicted. Then, of course, another aspect of integrity issue in terms of due diligence The integrity of the arbitrator is also very important, and desktop reviews about possible matters the arbitrator has dealt with and whether there are any integrity issues as regards the awards they have given before, or even as individuals themselves. So those are very critical, of course, in addition to the costs of the arbitration. And this can come in the point of maybe where is the arbitrator going to be located, because that may be an aspect of cost. So good to mention that, the background information about the arbitrator. Now, speaking to the issue on what in-house counsels need to take care of as they draft or review or negotiate for these arbitration clauses, the first thing is that the arbitration clause must be an arbitration clause which speaks to the particular contract in terms of carving out the specific expertise required. Of importance, it must speak to the scale and size of the contract, because you don't need to have arbitral tribunals which will cost you much compared with the contract price. They are how to be value for money proposition as well. Of course, very important is that it is important to have model arbitration or dispute resolution clauses, but then it is important to always customize those model arbitration clauses. They are meant to bring efficiency, but then that should not sacrifice having an arbitration clause which is relevant to the contract and which is fit for purpose for the purpose of the specific transaction. I think it's important to mention that. The other thing is, of course, let them take care of the timelines. Don't have arbitration clauses which are scalable or they are layered to the extent that no dispute will ever end, and the effect of that will definitely be undermining the whole principle for arbitration, which is, of course, timeliness of dispute resolution. I think those are the few I can speak to. Thank you.
Thank you. Thank you very much, sir. I'll go to Madam Hawa.
Okay,
Closing remarks.
thank you very much, Folake. So for me, I want to add to just to make this clarity that even in ad hoc arbitration, that you could also have an appointing authority. So where parties, except parties choose institutional arbitration, for instance, the center that have been chosen is to administer the arbitration. But in terms of having an appointing authority, then even where parties decide to go the route of ad hoc, I think it is important to also have an appointing authority in their dispute resolution clause. Because if parties are unable to agree as to who to appoint as arbitrator, whether it's a one-man panel or a three-man panel, three arbitrator panel, then there has to be an institution where you could easily apply to ask, okay, we're unable to do this and we require that you do it on our behalf. But it doesn't necessarily mean that the center or the appointing authority is to administer that arbitration or the dispute resolution. So I just want to make that clarity that even in ad hoc, you could still have an appointing authority, but not necessarily administering the arbitration proceedings or the procedure. So, and apart from that, I'll still go back to what I had said earlier, the fact that it is important, and that's why I feel this particular webinar is so key, that as lawyers, as counsel in-house, we have to understand what is required of a properly drafted dispute resolution clause. And I think the next thing, maybe I will suggest that the next thing that this committee should do is actually to have a master class where arbitration draftings are actually taught, because it is important that we understand. From what Mr. Julius have said, you could have everything wrapped in one paragraph or two paragraphs. You could also have a situation where you have to extend it to 2 pages. So it will be important for us to understand at what point do you wrap it up in 1 or 2 paragraphs, and then at what point do you ensure that it gets to 2 pages. So maybe we should also consider that, and this particular conversation is necessary, because for us in arbitration centers where that is the problem we see arbitration clauses, and we're unable to do anything about it. It's really saddening. Where you have parties draft arbitration clause, I know they said it's a midnight clause, but I think we should make sure that we open our eyes when we draft the arbitration clauses or the dispute resolution. You shouldn't be sleeping when you're doing it. It can't be that it is at the point where you have disputes that you begin to now ask yourself what to do in the circumstances. So lawyers and parties must understand the importance of drafting a well-drafted arbitration clause that is clear, that is unambiguous, that is capable of being enforced, and that is also will be capable to make sure that the whole dispute resolution procedure is expeditiously done, which is key in alternative dispute resolution. I think I'll stop here, and then maybe when we answer.
Thank you so much. I'm sure Dr. Esson has taken note of your suggestion. And with that, I'll just quickly go to Mr. Julius.
All right, so just to keep it brief, advice one, understand the counterparty, understand the transaction you're getting into, understand the risks that are likely to come out of it, and before you start drafting. And then you make sure that in drafting, you actually state what you intend. If you are not sure, get another pair of eyes to look at it, because clarity is really very key to this. And once you have put on paper what you intend, then you live with it.
Thank you. Thank you so much. Dr. Esson, I don't know if we have time for questions. We've gone well over the allotted time.
We'll just take one or two. I have seen a couple of questions in the chat room, and I'm trying to respond to some of them, but I don't think we should end. We have very limited time. We have exceeded the time, but it's been an engaging and interesting conversation. Maybe just about two. It's good to at least ask.
I think what we can do is take one from the chat box, and then I can see someone's hand is up. So Victor Akpeji in the chat box says, how do we resolve an ambiguity caused in a dispute resolution clause where there is lack of clarity on the institutional framework, or whether the arbitration is ad hoc or institutional?
Okay.
I don't know if who wants to.
I can attempt
Mr. Julius?
Okay.
Yes,
please.
So how do we deal with that? It depends on where the ambiguity is. I mean, if, for instance, it's clear that the parties intend that all disputes should be resolved by arbitration, and that the dispute is not over that, then of course you should go there and resolve it. But assuming the dispute is as to whether there should be arbitration or not, or which institution should arbitrate or not, you have set yourself up for either of two things. One, either the parties get together and agree on what they want at that point, or there will be litigation to sort it out for you.
Okay.
Yes, and just to add to that, and I think it's something I forgot to mention at some point, that the use of language also matters. You know, the use of shall and may. Sometimes you see in some arbitration clauses where it is said that parties may go into arbitration. That's a very difficult situation. And for me, I see that if it is an institutional arbitration, it will be clear. It will be clear where a particular institution has been selected to administer. And I think that's why I said it's important to have a master class on this, because when you say administer, it means that the institution will not only determine the arbitration, but also will have the opportunity to manage the whole process of the arbitration. And that is as opposed to an ad hoc arbitration, where parties will have to, by themselves, manage the whole procedure. So it's important that when we choose languages, the use of shall and may usually distinguish whether or not parties actually intend with good faith to go into dispute arbitration or mediation or whatever it is, as the case may be. Thank you.
Thank you. Thank you very
Okay.
much. I think we have
Can I
one
just
from
quickly
Benita.
contribute
Yes.
to that, discussion? It's like the two speakers have said, Mr. Julius and Mrs. Sawa, it's very important to get it right and to ensure that you are drafting a clause that it's capable of being interpreted. A pathological clause could end up with parties being in court for years, dispute before dispute, like Mr. Kito said. And this is something that, in terms of real life experience, is something that I have experienced. Unfortunately, we were handed over a contract where there's the BIMCO contract, like a template that you must attach to a contract. So in that template, it's typically fine prints, tiny prints. It read arbitration in London. Then there's an agreement that says arbitration in Nigeria, Lagos. And when the dispute crystallized, it was not a question of whether the arbitration was going to take place in London or whether it was going to take place in Nigeria. One of the parties favored arbitration in London, the other party favored arbitration in Lagos. And when one initiated the arbitration in London, the other sought a federal high court interpretation of what the arbitration agreement. And that went on for 3 years. And by the time the court eventually decided that the arbitration should be in Lagos, the other party had dissipated all its assets and there was no party to actually conduct an arbitration. So we could not resolve the dispute. So that is why it is very important when you are drafting an agreement to pay attention to it, to ensure that you're not drafting a pathological clause that is incapable of being interpreted or that will cause a dispute before even resolving the main dispute. So that's my contribution at this point. Thank you.
Thank you very much, Ma. We promised to take one raised hand. I think the first hand to come up was Benita Undu Okeke. Benita Undu Okeke, are you with us? Okay. I'll go to the second hand I noticed. Henry Chukunonzo.
Yes.
Okay.
For the time. I understand we are pressed for time. Thank you very much to all the speakers. Yes. Can't you hear me?
I'm sorry, the network is really bad. We can't hear you. If you could type your question. The network is really bad. We'll just move on to Henry Chukunonso.
Good afternoon to the organizers and the panelists. I thank you very much. Quickly to my question, whether I posted it in the chat box, whether it's advisable to include timeline for the arbitration process, that is between when arbitration is commenced and when award is delivered. Actually, I'm involved in one where the timeline was 23 days. And we're looking at whether a procedural order can cure that problem because there's no way we could achieve an award in 23 days. Whether it's advised to include timeline or in addition, where it has already happened, whether a procedural order can cure that very rushed timeline. Thank you very much.
Okay, I personally would say that the timelines would be useful when you're talking about delivering awards, the delivery of the award. But I'll let the speakers. I'll let Mr. Kito. Mr. Kito. Okay, I don't know who wants to take. Okay, yes, Mr. Kito. In a situation where the timeline is very limited, from the commencement to delivery of awards, can a procedural order cure it?
Yeah, for Lucky, my take would be that it's actually very important to have timelines, especially for dispute resolution clauses. But then it's also good to be wary that timelines should also not be there to compromise on the quality of the awards. Because they say that you can have an accelerated award which compromises the integrity and, of course, the competence of the award in terms of giving fairness to the parties and, of course, looking at all the submission documents submitted by the parties. So it is very important. But then in a case whereby you find yourself that the timelines are working against giving an award which is fit for purpose, I think you need to revert to the aspect of what we call the party autonomy, whereby now it's upon the arbitrator to call upon the parties and align them in terms of the need to extend the timeline so that then a fit for purpose award would suffice, instead of accelerating justice only for either of the parties to raise an issue as against the award that it was accelerated, or perhaps it overlooked one or two things in bid to comply with the timeline. So I think the aspect of the party autonomy can give a solution to that. And all the parties will be expected to look into that favorably. In the event that they don't do that, then I think it's also upon the discretion of the arbitrator to also find a way of being able to balance and ensure that justice is done a bit within the strict timelines.
If I may just chip in briefly on that, I'm not aware that arbitrators have inherent jurisdiction, to do things the way they want. So how you draft that timeline is really very important. If you draft a timeline that is unrealistic, people have tried to put in timeline, but what I would advise is allow scope for the arbitrators to be able to extend the timeline. And if time is so much of the essence, that's one of the reasons for institutional arbitration. If you go to institutions, they help to manage the time. The arbitrators they appoint know that you are not at large to just do these things, because a lot of times the challenge you have is the timetable, the calendars of the arbitrators, being able to come and deal with these things. But a lot of reputable institutions will rein them in. But going back to the question, it's going to be a tough one for the arbitrators if you have drafted it in a way that makes it mandatory that it must end by this time, without the arbitrators going beyond what they are allowed to do. So in drafting this, please make sure you use the right words. And I heard Madam Hawa talk about may or shall, which introduces some flexibility. But I also do make sure that wherever I find a timeline, I try to give the arbitrators also the flexibility if the need arises to extend that time.
Yes, okay. So I'll just add from my end that I was actually thinking about the party autonomy. If parties, from his question, if parties can sit with the arbitrator and extend the timeline. So for us, for instance, in this arbitration center where I work, we have our model clause, and because we're a dispute resolution center under a chamber of commerce, so which means that business is actually supposed to walk in and have their disputes resolved. We have an expedited procedure where arbitrators are required to manage their proceedings within 90 days. And then in the event that they are unable to finish the arbitration procedure within 90 days, then the arbitrators can, with parties' consent, sit to expand it within another 45 days. So we move from 90 days to 45 days, and then it is expected that's a total of about five months within which an arbitration proceeding is supposed to finish. So we have, there could be timeline, but there should also be flexibility, like Mr. Julius have said, for parties to be able to expand the time within which the arbitration can take place if if parties are able to finish the proceedings within the initial time that was initiated. So
okay, thank you.
again, it goes back to the drafting of the clause itself.
Okay. Thank you very much. We have gone way past the allotted time, and I will ask the participants, the people listening to us, attendees, to please engage with the speakers via LinkedIn or whichever way you can to get them to answer the other questions that have been left unanswered. With this, I would like to say a big thank you to the in-house committee, also to the Chartered Institute of Arbitrators itself for this great opportunity, and also the speakers, and most importantly, the people that have taken time out of their busy schedule to join us today. Thank you very much. Dr. Esan?
It's over to
you, ma'am.
Riti, who is the section.
Thank you very much. Thank you very much, Folake, for masterfully moderating this session. I would like to really appreciate all our speakers. Thank you, Mr. Julius Echikonye, Madam Hawa Usman, Mr. Ibrahim Kito. Thank you very much for the insights and the practical points you've given to every one of us. Would like to thank every participant joining us from different parts of the world. Thank you for staying true till the end of this webinar. We are not on our own. We are a branch attached to the Chartered Institute of Arbitrators Nigeria branch. So we'd like to recognize the presence of the chair of the Chartered Institute of Arbitrators Nigeria branch, Mrs. Olushola Adegbomire. Thank you very much for staying with us here. We also like to recognize Mrs. Mia SAN, thank the third vice chair of the association. Thank you very much for being here with us. We are grateful. We also recognize the secretary of Chartered Institute of Arbitrators Nigeria branch, Venerable Adeyemi Agbelisu. Thank you very much for being with us. I'm sure we have all learned. If you have learned something, could you put it in the chat room and also say thank you to our speakers. While we're doing this, we'll be calling on the chair of the Chartered Institute of Arbitrators Nigeria branch, Mrs. Shola Adegbomire, to just give us our closing remarks and thank our participants and speakers. Over to you, Mrs. Shola Adegbomire.
Thank you very much. I want to start by thanking the committee for putting together a great first webinar. This has been very interesting. Every single minute I have enjoyed, and I've seen people all posting how impactful it has been. So I thank the committee that put this together. And of course, this is the first one. So each one is going to get even better. So I said, don't miss any of their webinars. I want to thank the speakers. Mr. Echikonye, thank you so much. Unfortunately, they didn't allow you to ask that question about not incentivizing disputes. But well, I'm sure we'll have another opportunity to have you again and you can answer that question for the person. Mrs. Usman, General Counsel, at least now we know what are the things you look out for when appointing. And Mr. Kito, all the way from Kenya, even if it is virtual, but all the way from Kenya, you're welcome to Nigeria. Wish we could give you some Nigerian hospitality online, but well, we can't. We look forward to perhaps you'll be in Nigeria for the East Africa arbitration program in Abuja, and then we'll be able to give you some good Nigerian welcome. To Folake Sadiq, our moderator, you've done a great job. Ireti Oluwa, thank you so much. Dr. Esan, who conceptualized this idea of these webinars, great job. Ms. Justin Alewa, the number 2 in the Corporate Council Committee, thank you very much. I just want to thank everybody and everybody who attended. I mean, this has been amazing. We had up to 200 participants up to the end. 200 participants up to the end. So obviously, Everybody was enjoying what Mr. Jikonye was saying, what Mr. Usman was saying, what Mr. Kito was saying, and enjoying Folake. And we have a lot of our big people here. Ireti has mentioned them. Thank you very much. We look forward to so much more. I was going to talk about the things because Ireti said we should put in the chat box what we have learned. I mean, I've learned many things. I even like that one about when the lion and the shark are fighting, the venue is critical. So we know that venue is critical in arbitration, and many other things I have learned from Mr. Kito, from Mr. Jikonye, from Mrs. Usman. Thank you very much. We look forward to having you again with us, virtual, physical, but we look forward to having you again. Once again, thank you very much. And of course, we'll let you know when the next seminar is. Somebody wants to know if we earn CLE points. Yes, we'll make the arrangements for those who attend to get CLE certificates. Thank you so much. God bless you.
Thank you so much.
A wonderful rest of the week.
Thank you very much, Madam Chair. We have come to the very end of this webinar. We appreciate every one of you for staying through. Just watch out, we have other insightful webinars coming up.
You.
And we're also working on model. Yes, ma. We're also working on model arbitration, dispute resolution clauses you could adapt and use in your agreements. Watch out for that. We'll continue to engage with you. Thank you very much for attending. Thank you, Dr. Esson. Let's hear your voice. Thank you
very
so much,
everybody. Thank you. Thank you.
Thank you, ma.
Thank you, Mr. Julius, Mr.
Thank
Kito,
you.
Awa and Folake, and of course, our very own programs and events coordinator, Mrs. Ireti Oluwa Banjo. Thank you very much.
Dr. Esson,
yes,
Dr. Esson, we hope, Dr. Esson,
yes, ma'am.
We hope we can have a full master class, a full training.
We will put it together.
Yes, on this, so that they will have more time to speak to us.
We'll put it together very soon. Thank you.
Thank you.
All right then. Bye-bye.
Thank you. Bye, everyone. Enjoy the rest of your day.